Among the difficulties and challenges faced by school administrators is the complexity of education law, which is aggravated by the fact that only a few legal practitioners have paid serious attention on this field of legislation, and that there are only a few decisions in the Supreme Court relating to this field. Allow me to share with you some of my insights and learnings on education law. I hope that this video, together with the other videos that I may upload later, may help you understand this very interesting and colorful field of law. Let us begin by understanding the very sources of education law. First is you have the Constitution, which is the fundamental law of the land. Then we have statutes. These are laws or legislation emanating from Congress. And you have administrative policies. Administrative policies are the IRRs, the orders, and circulars. These three sources of law becomes the basis for our institutional policies. Our institutional policies, though not law, govern our relationships, govern our standards and whatnot in each of our schools. These institutional policies must be in congruence and must be in consonance with the Constitution, statutes, and administrative policies. Let us take first, sorry, let us take first the Constitution. We have the 1987 Constitution that was preceded by the 1973 Constitution and the 1935 Constitution. The 1935 and 73 Constitution no longer is operative in our jurisdiction. What is operative is the 1987 Constitution. So this law is the law of laws. It is the framework for legislation and governmental action. Anything that comes as against the Constitution is considered unconstitutional and may be seen to have no force and effect whatsoever. It may be questioned. Government actions and regulations that do not come as congruent with the Constitution may be subject of judicial review, a process that a procedure that we have in our system that may question the validity of any governmental act. And once the case is given favor by the court, such governmental act and even law will be seen to have no force and effect whatsoever because of this principle, the principle of constitutional supremacy. The principle of constitutional supremacy, well, it magnifies the idea that the Constitution is fundamental, it's basic, and it is supreme. In the case of Manila Prince Hotel versus GSIS, the Supreme Court explained this concept under the doctrine of constitutional supremacy. If a law or contract violates any norm of the Constitution, that law or contract, whether promulgated by the legislative or by the executive branch, or entered into by private persons for private purposes, is null and void and without any force and effect. Thus, since the Constitution is the fundamental, paramount, and supreme law of the nation, it is deemed written in every statute and contract. You have the Constitution permeating the relationship of government to us, citizens. And in fact, the Constitution permeating also the relationship of private individuals against each other or with each other. The Constitution, again, is so fundamental and basic and supreme that if any governmental action comes as against the Constitution, it may be struck down and eventually declared to have no force and effect. Again, laws emanating from, or the Constitution as a law must be the very framework and basis for laws, therefore, and of course for administrative policies. Any administrative policy that comes against the Constitution, any legislation that comes against the Constitution, they cannot have any validity. The provision of the Constitution is considered as self-executing. What does this mean? This means that the Constitution and its provisions must be considered as law by themselves. It means that except for the Declaration of Principles and Policies, the provision of the Constitution is a source of rights and obligations. You can require or expect from government to abide by its provisions without the need of an act of Congress, because its provisions are complete in themselves. So, for example, in the Bill of Rights, you can demand from the government that a search warrant, for example, is necessary before any law enforcer can come inside the premises of any private individual. You don't need a specific legislation for that because the Constitution already provides for it. You can require, or you can expect that the government shall respect the privacy of your communications and correspondences, meaning the government cannot just open your emails and your letters without your consent. It's a demandable right. There are provisions in the Constitution, however, that has no force and effect. I'm talking about the Declaration of Principles and Policies, for example. The Declaration of Principles and Policies are not sources of rights or obligations, generally speaking, because they are not complete in themselves and they require further legislative actions. So other than that, all the other provisions in the Constitution, generally speaking, are self-executing. They are sources of rights or obligations. The next source of law are statutes. What are statutes? Well, laws. But when you speak of law, the Constitution is also a law. But when you speak of statutes, while they are the same as the Constitution, they are called as laws. Statutes are laws coming from the legislative branch. The legislative branch in our Constitution is what we call our Congress. The Congress includes the House of Senate and the House of Representatives. We have this common usage of the word Congress to mean the House of Representatives, but actually in legal parlance, Congress means the House of Senate or the House of Representatives. Congress is made up of these two parts, the upper house and the lower house. Okay, so when you speak of statutes, these are laws emanating from the Congressional Act. This is the exercise of Congress of its legislative powers. According to Abacada versus Purisima, a case decided by the Supreme Court in 2008, reiterating the provision of the Constitution that legislative power, or the power to propose, enact, amend, and repeal laws, is vested in Congress, which consists in two branches or chambers, the Senate and the House of Representatives. A valid exercise of legislative power requires an act of both. The legislative process is very simple. A bill is proposed by a lawmaker. For example, the bill goes to a committee in either House, Senate, or House of Representatives for evaluation. And after that, its recommendation is appreciated by the House in effect as a plenary. So it could either be that this proposal uh, may emanate from the Senate or the House of Representatives, but after the committee evaluates a bill, the proposed law by a member of each house or a specific house, it passes to 3 readings. So for example, a bill is proposed in the House of Senate. It is submitted to the committee for evaluation, and the recommendation of the committee, if it's recommended for the readings of the plenary, will be subjected to intense deliberation in 3 readings. No, it is read in its entirety. It is deliberated upon. On the 3rd reading, the lawmakers cast their vote whether they agree on the proposal or not. So that is the process for one house only. After the deliberations in 3 readings in that specific house, it is passed on to the other house. If the proposed bill comes from Senate, after 3 readings and after the favorable vote, it goes to the other house. It goes to the House of Representatives to undergo the same process. It is again read in its entirety, deliberated, and then subsequently voted upon. If the bill emanates from the House of Representatives, still the same. It is undergoes 3 readings, and after a favorable vote, it goes to the other house, which is the House of Senate. The point is, bills may come from either the Senate or the House of Representatives, but it is passed on to the other house for voting also. After the voting in Congress by both houses, it is submitted to the President for his signature or veto. Okay, so what laws may Congress enact? You have to understand that the power of Congress is plenary. It's plenary because the explanation in jurisprudence is that a state legislature has plenary lawmaking power over all subjects, whether pertaining to persons or things within its territorial jurisdiction, either to introduce new laws or repeal the old, unless prohibited expressly or by implication. Meaning, Congress can make any law on anything. It's plenary. The power is plenary. It can have any matter be subject to any law, but there are restrictions. There are provisions in the Constitution that prohibits a legislation condoning the same or prohibiting the same. For example, title to royalty. Congress cannot make a law giving title to royalty to any person, making somebody a king or a queen. Okay? Prohibition is, for example, the passage of irrepealable laws. The Constitution directly says that there should be no irrepealable laws because irrepealable laws violate the plenary power of Congress. Because by a law being irrepealable, it will prohibit Congress in the future from amending it or repealing it. So kapag sinabi kasi, if we say plenary, it means it's the power, the unbridled power of Congress to enact laws. Okay? For whatever subject, for whatever purpose that the law intends. The next source of law are administrative policies. This includes IRRs or orders. If you notice, if you are a school administrator, we always refer back to for the higher education institutions, we always refer to the CHED memorandum orders or the CHED-RO orders. No? For those in the basic education, you have DepEd orders. Are they laws? They have the force and effect of law because of these orders being valid delegations of legislative power. the principle of delegation of legislative power generally is prohibited because what can be delegated cannot be further delegated, meaning it is the Constitution that delegates to the Congress legislative power. It cannot supposedly delegate it to another entity or office. But there are valid delegations of legislative power. One is the delegation to administrative agencies or offices. Delegation is essential because of the specializations of each administrative office or agency. We have to recognize that, for example, if it's on the matter of education, the DepEd and the CHED has the greater understanding on the matter. Like, for example, on the matter of environmental preservation and protection, laws, while they are complete, may delegate the creation of IRRs or orders to the DNR because of the specific expertise of the DNR. Like in education, the specific expertise of the CHED and the DepEd and the TESDA allows for the delegated authority for the DepEd, TESDA, or CHED to craft and impose their memorandum, circular, or orders for the schools. Okay, so while administrative orders, for example, from the DepEd, the CHED, or the TESDA are not laws, they have the force and effect of laws because these are valid delegations or of legislative powers. That is why we don't argue with the idea that why should we follow orders from DepEd, CHED, and TESDA because they exercise their powers conferred to them by law. Whatever TESDA, CHED, or DepEd directs have the force and effect of law, which must be complied with by all schools. So, following the Constitution, the statutes, and administrative policies, we have our institutional policies. Our institutional policies are internal rules and regulations of each school that we must abide with, but they must comply with statutes and the Constitution. Why? Because of the idea of constitutional supremacy I earlier discussed and the compulsory character of law. There's this principle of dura lex sed lex. The law may be harsh, but it is the law. You cannot go against the law. The Constitution and the statute, though they may appear to be compelling or sometimes harsh, are not negotiable in the matter of their compliance. Complying with them is not negotiable. You must comply with them. Dura lex sed lex. The law may be harsh, but it is the law. So when you craft, for instance, your school policies, you must not include provisions which are contrary to the Constitution, like when you have a policy prohibiting the free expression of your students. That, for example, the school paper, the student paper, yung kanilang newsletter must be regulated by the school and they cannot say anything contrary to the school. That is against the Constitution. And it cannot be made as a policy because of the principle of constitutional policy, supremacy, which, by the way, in the Constitution, there is the respect given for the right of the public to free expression, speech, and of the press. It includes the right of the student as far as their school papers or newsletters are concerned. Okay? The student publications. I am talking about the student publications. Now, the matter that we need to address next is important. This relates to the promise and commitment of the Constitution to quality and accessibility of education. The state shall protect and guarantee the right, sorry, the state shall protect and promote the right of the citizens to quality education at all levels and shall take appropriate steps to make such education accessible for all. You have highlights here: quality and accessibility. You understand that as far as quality education is concerned, it must be present in all levels of education, from basic education to higher education, from kindergarten to postgraduate education, and shall appropriate steps to make such education accessible for all. Because education that is not accessible is good as no education allowable for all. Okay? Promise becomes empty if it is not attainable or accessible. So, as far as quality education is concerned, in the words of Father Bernas, it's making sure that basic education is really solid. Because if it is not solid, may rippling effect siya. It has a rippling effect. It affects it affects the quality of secondary education. If secondary education is poor, then the person goes to college unprepared for college work. And if he is allowed to graduate again with a poor quality of college education, he goes to the university professional education even more unprepared. So, quality education has a rippling effect from basic education to professional education, postgraduate education. It must be possible and present in all levels of education. We have that observation from many teachers that some of their students that reach higher education have difficulties in certain competencies that becomes very challenging for them because these competencies should have been honed to the students earlier on in basic education. For me, the most important part of education is basic education because it gives the student the basic skills that would guide him to his intended path, and in fact allow him to possess the best competencies and capabilities that would ready him not only for high school, for college, but also not also for the postgraduate and graduate education, but also for his employment. What good is education if it is not of good quality, that we have graduates from so-called diploma mills who are not even capable of being employed or not truly employable, or those who um, do not have the basic competencies for effective employment. So that is where employees select their applicants for work who has the best credentials and who can respond to interviews by employers. They determine if the student is with certain competencies and capabilities, and good education gives us the sufficient competencies and qualifications for employment in the future. Quality education allows uh, us greater contribution to nation building. So there is so much burden and challenge to schools, to teachers, to give their best to their students who are the future of our nation. This case of UE versus Pepanio um, describes quality education for schools, ano? The operation of educational institutions involves public interest. The public is involved because why? Not only because it is where we source from our nation builders, but if you look at it from a more practical perspective from the parents entrusted to us their children, and it is by this that our exercise of our substituted parental authority gives us that greater burden because we are honing young minds. The government has a right to ensure that only qualified persons in possession of sufficient academic knowledge and teaching skills are allowed to teach in such institutions. Government regulation in this field of human activity is desirable by, for protecting not only the students but the public as well as from ill-prepared teachers who are lacking in the required scientific or technical knowledge. This may be required. They may be required to take an examination to possess postgraduate degrees. Sorry, they may be required to take an examination or possess postgraduate degrees as a prerequisite for employment. This may be an expectation both from the private or public schools. The government may provide for basic qualifications or may ask for basic qualifications from teachers because of quality education as an expectation from our stakeholders, the public. Ano? Um, Government may require, for example, for basic education teachers to have the licensure, to have taken and passed the licensure exam. For the college, for the possession of a master's degree in order for somebody to be qualified to teach in college, or for certain programs that it must be headed by somebody who has the PhD or expertise on the field. These basic state requirements allow for the bare minimum that would more or less guarantee that those who are teaching has the capacity to teach. For private schools, they may add more qualifications which are reasonable and in congruence to their mission and vision. Private educational institutions, in the case of Herrera Manawis versus St. Scholastica's College, must still supplementarily refer to the prevailing standards, qualifications, and conditions set. These limitations on the rights of private school, colleges, and universities to select and determine the employment status of their academic personnel has been imposed by the state in view of the public interest nature of educational institutions, so as to ensure the quality and competency of our school and educators. So the school has a say on the bare minimum that teachers and educators and schools must comply with because of the promise of quality education. This, again, private schools may add more to the qualifications of teachers that are fair and reasonable. The state shall protect also um, the that promise of making education accessible to all that is found in Section 1 of Article 14. Under the Constitution, access to education at all levels, therefore, if you look at the provision, does not guarantee free higher education. Under the Constitution, what is generally provided is the guarantee of accessibility, but it does not promise free higher education. Basic education is another thing, but for higher education, while it may be accessible, there is no promise under our law to have free education. Um, for basic education, that's another story, as I mentioned earlier, because under Section 2 of Article 14, The state shall establish and maintain a system of free public education in the elementary and high school levels. Free education is a matter of demandable right because the Constitution provides for it. But this education is only for basic education. Um, this is further supported by international law on the right to free basic education. In the Universal Declaration of Human Rights, the UDHAR, education shall be free, at least in the elementary and fundamental stages. Elementary education shall be compulsory. Further, in the International Covenant on Economic and Social Rights, and the International Covenant on Civil and Political Rights, this is reiterated. Primary education shall be compulsory and available free for all. Okay? Talking about basic education. That's why our Constitution is consistent with the international law on free education for elementary and high school students. This matter of accessibility is provided, however, not by the Constitution, but by legislation, by statute to higher education. Free education is not constitutionally granted, but it is guaranteed by statute for higher education. We have RA 10931, or the Universal Access to Quality Tertiary Education Act, which was approved a few years ago in 2017. This law gives free education in state universities and colleges, local universities and colleges, for all Filipino students who are either currently enrolled or shall enroll in SUCs in the Philippines, as long as they qualify the admissions and retention requirements of the school. This is a very interesting law that we may take up in a different video. For private education, there is a leeway, however. Kasi itong free education, well, what is directly mandated by the law is for state universities and colleges, di ba? While there is the promise of free education through statute, it does not prevent the operation of private education that can impose certain other requirements that many may contest to violate the matter of accessibility, but being a private institution, they are allowed by law to impose additional admission requirements. Entrance exams. No? In the case of University of San Agustin versus CA, the Supreme Court in 1994 declared that entrance examinations may likewise be imposed by private schools, aside from the basic or added documentary and other requirements. This is as they are afforded ample discretion to formulate reasonable rules and regulations in the admission of students, including setting of academic standards. Within the parameters thereof, they are competent to determine who are entitled to admission and readmission. Remember, you have private schools who are with such discretion to refuse students because of the failure of student applicants to pass or to take entrance examinations. That's over and above the bare minimum required by the state for the basic qualifications for public schools. For private schools, they may require further examinations and even further documentary requirements. The right to quality education in the case of, this is very interesting, Dex and versus San Diego. The right to quality education, cross-referring accessibility to quality. The right to quality education invoked by the private respondent here, who is San Diego, is not absolute. What happened here is that San Diego or the respondent rather applied for medical school, but he failed to take the qualifying exams for medical students. Okay, so because he failed to pass the qualifying exams for all medical students 3 times, no, 3 flunk rule, he was denied the entry to any medical institution, medical schools. The respondent invoked na education, I have the right to quality education, but does that violate quality education? Because he can also invoke here accessibility. Medical school should be accessible to him. He can say that. But according to the Supreme Court, invoking the right to quality, accessibility of quality education is not absolute. This Constitution also provides that every citizen has the right to choose a profession or course of study. That could also be that is also invoked by the respondent. Subject to fair, however, subject to fair, reasonable, and equitable admission and academic requirements. This is the limitation, the admission and academic requirements. The court feels that it is not enough to simply invoke the right to quality education as a guarantee. One must show that he is entitled to it because of his preparation and promise. You cannot force circular pegs into square holes. Maybe you may not qualify as a medical student, but you may qualify to other fields of learning. Maybe your calling is for some other field. So it's the Supreme Court telling us that we have quality education and its accessibility promised by the Constitution, but you have to show that you are qualified for it. Submit the necessary qualifications and show that you are competent. Okay, so it's not absolute. It's not absolute. For private education, accessibility means the restriction of private schools and the right of private schools to require the payment of tuition and other fees. While education may be free for state-run schools, for private schools, the payment of tuition fees are allowed, because how else can private schools operate and either than the collection of its lifeblood, the tuition fees of students? Supreme Court recognizes this. In the case of St. Joseph's College versus Samahan, at the onset, the Supreme Court said, let it be clear that this court understands the plight of private schools and their need to support their operation from tuition income. Okay, we realize that their role in educating the youth and in molding them as responsible citizens. In the sense, private schools perform an indispensable task in nation building. Hence, they deserve the support and the state to help them carry out their sacred mission. And one of the support the state can have for private schools is its permission to exact or require the payment of tuition fees, among others, because the state can also support private schools through scholarships or other means, no, to assist schools to allow them to operate effectively. So that's the case of St. Joseph's College versus Samahan, okay, where the Supreme Court really recognizes the need for the schools to collect tuition fees. Schools can even refuse students for non-payment of tuition fees. Since in this case, since petitioners in this case of Tan versus CA in 1991 failed to comply with the condition and prerequisites for admission, as the registration and the payment of prescribed fees and so on, the school cannot be regarded as having acted arbitrarily in capriciously in refusing to enroll or re-enroll petitioners. you cannot compel schools to accept you even if you have no tuition fee to pay. But knowing most schools, what you can do is to create a sort of scheme so that students can still attend with pending accounts. Because anyway, you can withhold your student records in the end for failure of the student or parents to pay their fees. You have that prerogative. This matter of online learning and accessibility. One of the difficulties in learning during the pandemic in 2020 to 2021 and even part of 2022 is the challenge of the delivery of education online. Some students have difficulties in accessing the internet, which is the source of instruction or the medium of instruction, platform of instruction for many schools, including the public schools, but mostly the private schools. For the public school, they have modules and the submission to schools of the accomplished modules. For other schools, they are internet intensive, so they do their online instruction through the use of LMS or the Zoom or Google Classroom or other video conferencing um, technology. But what hampers us is not only the ex, how expensive our internet connections are. That's why many students cannot attend class because they have no load, or they do not have any gadgets. But it's more also of the capability of our internet providers, because the internet has become part of our human reality in the modern age. And during the pandemic, the inefficiency of telcos are highlighted, though they are doing their best, but I think more can still be done. No? Do we have a constitutional support for requiring effective internet connection? Remember that the Constitution was promulgated in 19 or ratified in 1987 when there was yet no internet. Yet there is a provision in the Constitution we call the Braid provision, proposed by Florangel Rosario Braid. In Section 10 of Article 16, the state shall provide the policy environment for the full development of the Filipino capability, and this part is important, the emergence of communication structures suitable to the needs and aspirations of the nation, and the balanced flow of information into and out of and across the country in accordance with a policy that respects freedom of speech and of the press. This provision may be a source of the basis for our right to demand for a more efficient internet connection. So, do we have the necessary communication structures now that would allow for the efficient flow of information within the country and outside? We have good communications facilities provided by our leading telcos and the emerging new ones. But I think from our experience, more can still be done. More can still be done. So, system of education. The Constitution says in Section 2 of Article 14, the state shall establish, maintain, and support a complete, adequate, and integrated system of education relevant to the needs of the people. The system of education must be complete, adequate, and integrated, and must be relevant to the needs of the people. The system of education permeates from kindergarten to the postgraduate. It must be a system that is effective in allowing the students to become effective contributors to society in the future. In Section 3 of Article 14, the Constitution provides that they shall inculcate, okay, referring to schools, they shall inculcate patriotism, nationalism, foster love of humanity, respect for human rights, appreciation of the role of national heroes in the historical development of the country, teach the rights of the students of citizenship, strengthen ethical and spiritual values, develop moral character and personal discipline, encourage critical and creative thinking, broaden scientific and technological knowledge, and promote vocational efficiency. This is the system of education that the Constitution aspires for. Integrated, relevant. Di ba? Legislation augments this. Okay? Where BP 232 says that the educational system shall provide for a broad general education that will assist each individual in the peculiar ecology of his own society to attain his potential as a human being, enhance the range and quality of the individual and group participation in basic functions of society, acquire the essential educational foundations of his development into a productive and versatile citizen. That's BP 232. The system of education must develop the human being, the student, the learner, to attain his full potential. He must be able to effectively immerse himself and function in society. And he must be, in the end, a graduate who is able to contribute constructively as a citizen. Education system shall train the nation, ideally should train the nation's manpower in the middle skills, in the middle level skills for national development. It must develop the professions that will provide leadership for the nation in the advancement of knowledge for improving quality and human life, and must respond effectively to the changing needs and conditions of the nation through a system of educational planning and evaluation. Ideally, the system of education must give the basic skills to the students. It must provide for the opportunity for students to become or develop in them their leadership capabilities, and it must adapt to the changing times. That's why a teacher must also never stop learning, and the school must never stop innovating, because we have to adapt to the changing needs of the times. BP 232 further provides that this system must aim to inculcate love of country, teach the duties of citizenship, and develop moral character, personal discipline, and scientific, technological, and vocational efficiency. Furthermore, the educational system shall reach out to educationally deprived communities in order to give meaningful reality to their membership in the national society, to enrich their civic participation in the community and national life, and to unify all Filipinos into a free and just nation. So not only should the system be inclusive for all, it must be unifying, and it must be um, uh, complete enough to provide for students who are morally upright, disciplined, but technologically and vocationally capable. For higher education, the CHED, the Commission on Higher Education, further provides for what the system of education should be. It must produce thoughtful graduates imbued with the following. One is values reflective of a humanistic orientation, makatao, okay? Analytical and problem-solving skills, the ability to think through ethical and social implications of a given course of action, and the competency to learn continuously throughout life. If you look at the expectations by law, we schools are expected not only to provide skills, but really to have for the students, but also to have them acquire the necessary moral perspectives, no, to allow them to be effective citizens. Further, for higher education, they must be able to, more importantly for me here, is they must be taught that education must be continuing. You don't stop learning when you graduate from college. You must continue your learning throughout life. That's why certain schools, like in our school in Ateneo de Davao University, have certain programs for continuing adult education. You might also be interested to have continuing adult education to your individual institutions. In the student's life, the role of the family is important. The Constitution provides that without limiting the natural rights of parents to rear their children, elementary education is compulsory for children of school age. So the Constitution provides that the primary natural right to educate belongs to the parent. That's why it is also, while it is a right that they can impose as parents for their children, they also have the duty, the natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character shall receive the full support of government. They have the right to discipline their students, their children. Parents have the right to mold their students into whatever mindset that they desire, but they have the duty to send their children for formal education. Free na nga eh, di ba? For basic education, and now, just recently, for higher education. So it's provided. What the parents are, of course, basically expected to do is to create that mindset for their students to learn, to have them understand that learning from schools is important. BP 232 provides further that parents shall be obliged to enable their children to obtain elementary education and shall strive to enable them to obtain secondary and higher education in the pursuance of the right formation of the youth. It's now recognized in BP 232, or since um, the effectivity of this law, that really the parents are obligated to send out their children for learning in schools. Parents shall cooperate, in fact, with the schools in the implementation of school program, curriculum, and program curricular and co-curricular. They have to not only send their children to school, but must show their support for the educational intents of the school as shown in their curriculum, and also, in fact, support their students, their children, when they perform extra or co-curricular work. Academic freedom is very touchy a subject for professionals, for educators, and for schools. The Constitution provides that academic freedom shall be enjoyed in institutions of higher learning. This is provided in the Constitution. If you compare this to the previous constitutions, in the 1973 Constitution, it says that all institutions of higher learning shall enjoy academic freedom. So it refers to the institution per se. No? In the 1935 Constitution, universities established by the state shall enjoy academic freedom. It's limited to those which are established by the state. go back to the 1987 Constitution, the prime difference is that there is the recognition now that academic freedom does not only belong to the academic institution, but in all of such institutions, meaning not the school alone, but by the faculty and perhaps by the students also. So primarily, academic freedom is enjoyed by the by in all institutions of higher learning, may specifically in college, hindi basic education but in college, because for basic education it is intensively regulated because of the social interest that basic education has. But for higher education kasi is the colleges become the source for research, for dialogue, for discussions, for innovations. It is the place that allows for discourse. And if the school, higher academic institutions become ineffective in discourse propagation or promotion when it is hampered by the state. So academic freedom is enjoined inside the institution of higher learning by the institution in itself or by its faculty primarily. But what about the students? Foreign jurisprudence would say that it's only the schools and the faculty that has academic freedom, but this must be reconsidered, considering that we do not have jurisprudence for this yet. Students have their right anyway, as narrated in the Bill of Rights in the Constitution in Article 3, including the right to free speech, press, diba, assemble, to organize themselves, and so on. And their rights are so protected and enshrined in Article 3 of the Constitution and the Bill of Rights. However, you have to understand that the nature of universities is that students and the teachers come together in academic freedom in search for truth. The university is a marketplace of ideas. So when the students does research by themselves or in collaboration with teachers, they must be afforded academic freedom. They must be given academic freedom over and above their civil liberties granted in the Bill of Rights, because they do research and they discover and innovate truth. No. So what is this thing called academic freedom? In the case of Son versus UST 2018, the Supreme Court narrates that the essential freedom subsumed in the term academic freedom encompasses the freedom to determine for itself on academic grounds who may teach, how shall it be taught, who may teach, what may be taught, how shall it be taught, and who may be admitted to study. This is the academic freedom enjoyed by the school, okay, by the institution. The institution has the prerogative to decide who can teach. So it has a discretion on the qualifications of teachers, for example. What may be taught, because it is not the teachers that determine the curriculum, but it is the school. And the teachers, though they have their certain freedoms inside the classroom, must still follow the curriculum, must still follow the study plan set by the school, how it shall be taught. That's why the teachers may be regulated in their manner and method of teaching. That's why especially for private schools, there may be observers that come inside the classrooms to determine that whether or not the teachers are up to the university or college standards in their manner of delivery of their instructions, and who may be admitted to study. It's the fourth freedom of the school. No? This freedom on who may be admitted to study is the right of the school to reject students who are not qualified based on their academic credentials, as well as yung entrance examinations. So remember that case of Dex versus San Diego, failure to enter into an academic endeavor because of the failure of the student to academically qualify. For private schools, you have private schools implementing entrance examinations. No, that's part of academic freedom for the schools. And this academic freedom of the schools um, includes the right of the school to discipline the students. In the case of DLSU, De La Salle University versus CA in 2017, discipline is part of academic freedom. It is true that schools have the power to instill discipline in their students as subsumed in their academic freedom because we teach our students value. So when we teach our students value by disciplining them, by submitting them to our harsh disciplinary standards, it is because we want to teach them values. We want to teach them to be effective citizens. Also, mission and vision. Each higher educational institution may have the freedom to pursue its own mission and vision. This institutional academic freedom includes the right of the school or college to decide for itself its aims and objectives as to how to best attain them. So that's the direction of your school. That's part of your academic freedom. The higher level of education with which the schools uh, possess is by virtue of its pursuit for truth. In schools, in HEIs, critical minds are molded free from predefined principles and ideologies. Essential skills and capabilities are honed, and dialogue and discourse are open in higher educational institutions. Too stringent state restrictions may hamper the free flow of learning in schools. That's why there are many advocacies that would emphasize that academic freedom belongs with the schools, the HEIs, and not with the state regulatory agencies, therefore. Remember, the Constitution says that academic freedom shall be enjoyed by all institutions of higher learning. It does not say there that it must be granted by state regulatory agencies. Further, as far as the academic freedom of the HEI is concerned, um, what the law provides is that the state shall anyway exercise reasonable supervision and regulation of all educational institutions. The operative word there is supervision. Supervision means only overseeing. Therefore, it may only oversee but not control educational institutions, specifically HEIs. The power of control is the power of an officer to alter, modify, or nullify, or set aside what or was done, um, and to substitute another's judgment of what a subordinate may have initially set out. No? So it's to supersede, but supervision has no power of superseding. It only is overseeing. And this is what CHED is doing. It oversees. And as it oversees, it creates for the bare minimum for our programs. It's to regulate, it's supposed to regulate the standards for the delivery of education. In Son versus UST, there is the recognition that indeed the Constitution allows merely a state's regulation and supervision of educational institutions and not the deprivation of their rights. That's why there are many universities out there that would produce new programs and specializations because the institutions may have seen the necessity of offering those programs, and those are part of their exercise of their academic freedom. What that CHED only would do is to oversee and to see to it that these offered programs comply with the basic standards that it has set. For the faculty, they possess actually academic freedom. But this academic freedom that the faculty of the higher educational institutions possess, they are highly influenced by um, foreign rules, no, regulations or jurisprudence. For the faculty, they have three main freedoms: full freedom in research and publication of the results. Okay, but the qualification is that they must be able to adequately perform their duties. So they can conduct any research or study and even publish books. The schools cannot hinder them. For example, they may have done their political research, for example, on a certain result, projected result of an election, and the result may, for example, have a contrary finding or conclusion that contravenes with the political stance of a school, if there be any. The school cannot prevent or silence the researcher, the faculty, into the delivery or publication of his results. Teachers have the freedom in their classrooms to discuss their subjects. However, in the discussion of their subjects, they may only mention or discuss what are considered as relevant and congruent to what their uh, topics or courses necessarily include. So they cannot get into politics, too much politics or too much partisan political perspectives if it's not relevant, for example, in the field of theology, or they cannot discuss so much about the arts or human sexuality if their topic is engineering principles. No? These are not relevant to their fields of specialization for some teachers or their topics in their subjects being taught. So your topic your topics taken in your subject must be in line with what the course is all about. And when the faculty members speak or write in their capacity as citizens, they are free to do so. And they may not be hampered by the school. If specialists in a university, PhDs are interviewed about, for example, political scientists are interviewed on TV, they can say whatever they want for as long as they do not take or carry with them the name of their schools, and they cannot be prohibited from airing out their views on political or social concerns. In the case of Garcia versus the Faculty Admission Committee of the Loyola School of Theology, the individual faculty member has the freedom to pursue his studies in a particular specialty and thereafter to make known or publish the result of his endeavors without fear and retribution to visit him in the event that his conclusions are found distasteful or objectionable to the powers that be, whether it be political, economic, or academic establishments. As I mentioned earlier, the results are your results of your study, and then because these are the results of your evaluation and your research, the school cannot silence you. That is part of your freedom. Unless perhaps if your findings or research are ill-mannered or indecent or whatever, but well, that's subject to certain specific scenarios, And Alersi versus Salgarino says that academic freedom of faculty members refer to the freedom of teachers from control of thought or utterance of his academic research findings or conclusions, and has nothing to do with the discretion of teachers to pass or fail any of her students according to his discretion. The indiscreet passing or failing, kahit na pumasa yung student, bawal yan. Yung power tripping, ego tripping, just because you don't like the student, you'll fail him. If the student complied with his requirements, school requirements, and passed the academic requirements, and there is has reached the average standard for passing, pass him. It is not up to you to arbitrarily say pass or fail, even if the student has already passed, because the standards that you are supposed to follow are the standards of the school, not your own standards. Academic freedom in the pandemic, well, when we delivered our instruction during the pandemic in 2020, 21, 22, we were given the parameters and permissions of SHED, allowed to improvise on our teaching methods. This is part of the freedom on how it shall teach, schools shall teach. Religion, well, there is a provision that the separation of the church and state shall be inviolable. But this is more of a restriction by the state or against the state and not of the schools. No law shall be made respecting an establishment of religion or prohibiting the free exercise thereof. Um, in relation to that, you have Section 3 of Article 14 making making religious instruction optional in public elementary and high school, um, at no additional cost to the schools or from the students. And it must be voluntary, consented to, and the instruction must be from the authorized representatives of the schools, public schools. For private schools, religion may be taught because you can anyway refuse to enroll in private institutions. You have a contract kasi with private schools. If you enter into such schools as Catholic schools or, for example, with New Era for the Iglesia, uh, these religious schools can teach their religious courses, and you have to take and pass them in order for you to graduate. Because in the first place, when you enroll in the schools, you know that these are religious schools, and you are bound by the contract that you have with the schools upon enrollment to complete all the subject in each curriculum for each student. Taxation and ownership, well, you have the provision in the Constitution that all revenues, assets of non-stock, non-profit educational institutions used directly, actually, and exclusively for educational purposes shall be exempt from taxes and duties, referring to all revenues and assets of non-stock, non-profit educational institutions. For proprietary educational institutions, including those cooperatively owned, may likewise be entitled to such exceptions, subject to the limitations provided by law, including restrictions on dividends and provisions for instatement. The privilege on taxes and as to revenues and assets is different for proprietary institutions as compared to non-stock and non-profit institutions. For proprietary educational institutions, they may be exacted with income taxes, business taxes, and withholding taxes. For non-stock, non-profit institutions, all revenues and assets of non-stock, non-profit educational institutions used actually directly and exclusively for educational purposes shall be exempt from such taxes and duties. The qualifier is that should be non-stock and non-profit, and this must be used actually directly and exclusively. So if a school earns profit from their commercial spaces, there are many private schools that have commercial spaces. These are not necessarily directly, actually, and exclusively for educational purposes, unless such commercial spaces are also laboratories for students of business or entrepreneurship. Maybe it may be it may have certain implications on revenue. Um, there are criticisms on church-run schools and why they are exempt from taxes. When churches operate schools and they are exempt from taxes, they are exempted not because they are church-run, but because they are non-stock and non-profit. Non-stock and non-profit schools um, are exempt from taxes because while they are exempt from taxes, all the revenue that they earn from the tuition fees go back to the students in the form of improved services. um, Salaries of teachers, because private schools do not have any subsidies of practically anything from the public. They are self-sustaining. For both proprietary and non-stock schools, they are exempt from certain taxes. No? For example, from grants, endowments, donations, and contributions in Section 4 of Article 14. They are also exempted from realty taxes as stated in Article 16, paragraph 3 of Section 28. As far as ownership is concerned, educational institutions um, um, has a certain limitation set by the state as far as ownership is concerned. There is a limitation as to the interest or business interest shares um, of um, of schools, no, as to the number of uh, ownership of such institutions in or number of stocks. In section 4 of article 6, it says that educational institutions other than those established by religious groups and mission boards shall be owned exclusively by citizens of the Philippines or corporations or associations. 60% of capital is owned by such citizens. The control and administration of the educational institution shall be vested in citizens of the Philippines. So, who may be president of a school, control and administration of such institution shall be vested in citizens of the Philippines. Who may own such schools, citizens of the Philippines, except when they are run by religious groups or um, mission boards. We will actually, I will post more videos on this matter of education law. Um, I hope that this discussion may have helped you in any way. Thank you very much for viewing.